Your Honor, just again, that we've discussed the plain language of the statute, and Your Honor, again, the
well, the plain language says that they're supposed to appoint one of these what do they call it? Compliance review panels.
Yes,
you keep calling it committee, but same thing. So a compliance review panel, and there's apparently no dispute that he asked for that, and they didn't do it.
Correct.
The county didn't do it. Okay. All right. Back to you, Ms. Jones, or you, Mr. Chumley.
Yes, sir, if I may. Since I'm the one that threw McQuaid into the mix before we took the break, I thought
I did.
So I thought I'd let Mr. Chumley off the hook on to respond. I'll try to respond. I'd like to respond just briefly to some of the things that he raised. First, I think the most important thing about McQuaid is that this decision, and one of the reasons I brought it out was because it was a 2010 decision, and I think it's probably the only one since the statute was changed in 2008. But the significance of the change in the statute, Judge, is recognized by the court in the paragraph that right before the paragraph you were reading from.
Yeah, but actually, you know, the rehearing was just denied January 25, it says, of 11.
No, I didn't even pick up on that. So it's only a year old.
Less than a year old.
Less than a year old.
Last looked at it. Now go ahead.
Yes, sir. The significance of McQuaid, and the reason that I thought it was an important case, is because it describes in that paragraph, starting with "for this reason" and talking about Cosgrove, and it says 112.534 was, quote, "no more than a vehicle for enforcing the procedures established in the preceding sections of this part of the statute, and not a vehicle for restoration of the substantive rights, whether those are sought by mandamus, injunction, or an action for damages." So we believe, Judge, that you understand what the purpose of the Compliance Review Board is. If there's a violation alleged during the course of an investigation, that's the purpose of that statute. And the end result of a compliance review, if you said today, give them a Compliance Review Board hearing, the end result is going to be that either the agency or the investigator will be reported for violating some intention. It has to be an intentional violation. But there won't be a review by that board of the substantive issues raised in the internal investigation. They'll look at the actions of the investigator or the agency, not at the substance of the investigation. So,
in fact, it specifically says under 112.534E that the compliance review panel's the evidence it hears and receives, quote, "shall be strictly limited to the allegation under consideration and may not be related to the disciplinary charges pending against the officer," period, close quote.
Correct. Yes, sir. Yes, sir.
So they can't even look at the, it's not like another look or examination or consideration of the evidence that exists or doesn't exist that supports the termination.
Correct. If an investigator out and out lied about something that they alleged to have come up during an investigation, and that is proven to the Compliance Review Board, yes, that investigator lied, the board is not going to look at the substance other than to say that investigator needs to be removed, someone else needs to be put in place to finish this investigation. Again, we're talking about during the process of the investigation, not after it's concluded. And then go forward with an investigation of that investigator. That is what that is all. That's what that whole statutory.
Say, for example, I'm not asking this to be cute about it. I don't fully understand all of this by experience. I noted in the statute, I believe I noted, I read, that one of the rights is that you do not have two investigators questioning, as you see on television and the like. Apparently, we don't have such a statute for people who are actually accused of crimes. I think they have to investigate. But here, they say we don't want that for law enforcement officers who are being investigated. We just want one investigator to be asking the questions. Not the, what was it, Starsky and Hutch or something, where we have
good guy bad.
Yeah, all right, whatever that is. And let's say that wasn't done. It was intentionally violated. Then the lead investigator, or both those people that did that, or whoever that intentionally violated that, if the compliance review panel found they did, they would then report that to the agency head, who would remove that investigator or those investigators. But whatever was gleaned as a result of that questioning, it's not like fruit of the poisonous tree in criminal law. And in fact, if that's otherwise supported, or perhaps they could even still use that correct? I mean,
Yes, sir. Yes, sir.
If it
Yes, sir.
wasn't coerced, if it was freely and voluntarily given, if it was reliable and trustworthy, the fact that there was an intentional violation resulting in the removal of the 2 investigators wouldn't necessarily vitiate the importance of some statement that was made.
No, sir. It's a separate vehicle, really. I mean, the disciplinary process that's beginning for Mr. Gardner, he has to file a notice of appeal within 10 days. The personnel board hearing will be convened, and as the person for the county who has done more probably personnel board hearings in the last 20 years than anyone else in this room for sure, I can tell you that the board will consider anything. If they want to bring in that his rights were violated, that is absolutely something they can bring to the board's attention to try to say, well, this evidence was tainted because the investigator did A, B, or C.
And you're representing as an officer of the court right here, and as one who has done that and might be involved in doing it in this case, that you wouldn't even object on that ground.
Absolutely, Judge. Absolutely. And secondly, something was brought up about the investigation with regards to the licensing, the CJSTC investigation of the termination, because that is reported to FDLE, and the internal affairs file is submitted to FDLE. But also as an officer of the court, I can tell you that FDLE does their own investigation when they're going to determine whether or not to take someone's license or suspend their license or take action against a law enforcement officer's license. So the concern that I think I'm hearing from Mr. McKinnon that this folder with these violations in it is going to be given to FDLE and no one will be able to argue on behalf of Mr. Gardner that something was done improperly during the investigation. That's not how that works, Judge. So if I could just summarize, I made a couple notes. The purpose of this is to protect the rights during the course of an investigation. The distinction on McQuaid is that, and the court points out that under the statute prior to 2008, injunction was the only remedy for an allegation of a Bill of Rights violation. That's no longer the case. Mr. Gardner can sue us in civil court if he wants to for wrongful termination and bring up these allegations. There seems to be a great concern that he doesn't have any other remedies, but he does, in fact, Judge, including the personnel board, petition for certiorari if the personnel board and the county manager upholds the termination or does any other action that he wants. He can take a petition for cert to the circuit court. He could bring criminal charges for official misconduct. If someone has violated 838.022, he certainly can go to the state attorney's office and file criminal charges against that person to be investigated by the state attorney or report it to law enforcement. We think it's important, Judge, that we tell you that we concur with your understanding of the statute. That is our understanding of the statute, having worked with it for a number of years. And we think that an injunction at this point is not the proper remedy for the concerns that he has with regards to the conduct of the hearing that is now over and concluded.
You think that the language I read from the end of the majority opinion in McQuaid near the end, that if he could show prejudice in the proceedings before the commission, which in this case would be the personnel review board, that then he could be entitled to reinstatement on the basis of that violation.
Well, yes, sir. And first I should say I don't necessarily agree that PERC and the personnel board are exactly the same.
I haven't intended to adopt that I think they are, but I think, again, they're roughly analogous.
Sure.
I don't know enough about the commission or the personnel review board to be able to say they're the same, and I doubt they are, but they
it's
have
an appellate
similar
review,
roles.
right? But what you read, Judge, is to say either in this case because the officer did not seek an injunction from the circuit court before he was dismissed, and again that was the only remedy at that point, or show prejudice in the proceedings before the commission. Well, that's what we're talking about. If you're talking about showing prejudice, it's the same argument. If you're going to say he could show it before PERC, he could show this before the
For
personnel.
example, going back to my hypothetical about two people questioned, let's change it from that and say that there was an, I'm not trying to be cute here, and this is serious business. I know we've had a few smiles during the course of all this, but we're dealing with professional lawyers who understand these things. So, but if someone were, hypothetically now, tricked into signing something that they were told they were signing this, and it turned out they were signing a, quote, confession, close quote, of some wrongdoing, that would, in fact, be prejudice. In other words, that could result, obviously, in, if that's the basis or a significant, substantial contributing basis for the dismissal, then obviously that could be a ground for reinstatement.
Yes, sir. The Personnel Board is not bound solely by what is in that internal affairs investigation. They make their determination based on what the parties